Good morning. My name is Alisa Lombard. I'm a lawyer with the law firm of Samaginus Lombard here in Saskatoon. We carry on a national practice and we represent over 100 women, Indigenous women who have been sterilized without consent. And so I'm here to talk today about consent, the context in which it comes up, and also the right to privacy and how those things are connected. One of the things that I've come across in some of my legal research that ties very succinctly to the types of cases that we're advancing is that there isn't necessarily knowledge among birthing women that they have a right to bodily autonomy, and that right is guaranteed by the Canadian Charter of Rights and Freedoms under Section 7, which provides very clearly that everyone has the right to life, liberty, and security of the person, and that the right not to be deprived thereof, except in accordance with the principles of fundamental justice, is at issue in these particular circumstances. Now, when we compare this right with other rights under the Charter, such as the right to be free from arbitrary searches and seizures, what we note is that in one particular context that deals with property and, of course, the person to an extent, authorities are required to bring those constitutional rights to the attention of the person who is considering foregoing them in any particular circumstance. But that's not the case when we talk about birthing Indigenous women, and we say that it should be, and that it would necessarily result in an immediate prevention of this practice of forced and coerced sterilization. And so, beginning with Section 7, as I have, it's very important to understand that there has been a separation in how the court has treated privacy, or the right to privacy, when it deals with either 1, civil cases, or 2, criminal matters. But in either case, it ties the right to privacy very closely to reproductive decisions. The Supreme Court of Canada, in the case of R versus Morgan-Tyler in 1988, at page 168, said, and I quote, that if the right of privacy means anything, it is the right of the individual, married or single, to be free from unwanted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. And so we also say that it is an assault of a sexual nature to sterilize a person without consent, and we ground that in some jurisprudence that does speak to that, but also more recently, statements made by Chief Commissioner Leckie before the House of Commons on June 18th, 2019. And so, going back a little bit, it's also important to understand where this practice came from and what kind of people thought that it was okay to encourage and persuade Indigenous women, if not just directly sterilize them without consent. What ideology was informing them, quite apart from racism, which we already know is a rampant systemic issue. It's important to look back and see how did this come to be, and what leftovers are we dealing with that continue to cause the problem today. I can say that it's perfectly legal for sterilization to be performed where the patient provides valid consent. That's in Cataford versus Moreau from 1978. That's a very well-established principle. Now the issue becomes what constitutes valid consent. So the notion of fundamental personal choices is really entrenched in that Section 7 of the Charter, the right to life, liberty, and security of the person. And that includes protection against state-induced serious psychological stress, as well as freedom from endurance of intolerable stress. And those principles are both grounded in case law arising from the Human Rights Commission in British Columbia, as well as the Supreme Court of Canada in Carter versus Canada. And so we know these things. One of the seminal cases that has come up, or that was determined, in fact, in 1986 by the Supreme Court, was Eve v. E. And it essentially established that a guardianship, to put it plainly, prohibits the authorization of procedures that are non-therapeutic. And here it's important to understand that sterilization, a tubal ligation, or getting your tubes tied, is always considered to be non-therapeutic. It is always non-emergent, and it is always not essential. Whether it is medically advisable may be the subject of consideration between a physician and their patient, but that gives rise to a whole other level of need for disclosure and a very firm understanding that the patient is the boss in that situation. And all risks disclosed, it remains up to the patient to determine whether or not she wants to undergo the procedure. So the court found in that particular case that physical integrity and its maintenance is of utmost consideration as a social value. So physical integrity attaches very closely to self-determination and to bodily autonomy. And these principles stand in the very stark contrast to the very insidious and ill-gotten ideology of eugenics. So this results in what I like to call a thundering clash in the reproductive experiences of Indigenous women. And so to get a sense of what eugenics means, it is defined by the Merriam-Webster Dictionary as, open quote, the practice or advocacy of controlled selective breeding of human populations, open parenthesis, as by sterilization, close parenthesis, to improve the population's genetic composition. So eugenics was a practice that was legislated provincially in both British Columbia and Alberta, and it failed by a single vote in Saskatchewan, which doesn't mean at all that the practice didn't go on and wasn't implemented in other more insidious ways. Well, Dr. Erica Dick is a professor at the University of Saskatchewan here in Saskatoon, and she wrote a very illuminating book called Facing Eugenics, Reproduction, Sterilization, and the Politics of Choice. Because after all, this is what we are talking about in this case. We are talking about choice. This is not a case about, or this is not an issue of, what the choice necessarily is. This is a case, and it is an issue about Indigenous women having all of the information that they have the right to have under the Constitution and the applicable law, and making a decision that is right for them, whatever decision that is, in the atmosphere and in the circumstances that they have a right in which to make that decision. And so Dr. Dick's work really stops short of the early 1980s, which is when the charter came into effect and when the doctrine of consent started to undergo quite a bit more massaging. But she does provide a lot of evidence and insight into how eugenics permeated the consciousness of the Canadian healthcare system. And frankly, in my opinion, I really think this eugenics ideology festers in the very broad discretion afforded to physicians, and that it's really pollinated by systems that have failed to meaningfully hold health professionals accountable for decades and to protect the oppressed and marginalized population. And also fail to uphold the rule of law with respect to the doctrine of consent and the right of their patients to bodily autonomy in their own institutions. These failures, I think, have really nurtured a sense of non-consensual sterilization through inadequate and unenforced consent processes to this day. And so, to put it in the words of an MP, or I believe it may have been a senator, in front of one of the committees that I presented, himself a physician, He said, "I know that some of my colleagues treat consent very casually." And so consent to an irreversible, permanent birth control method should not be casual, is our position. And so there is a whole hoard of information within Dr. Dick's book that speaks about what these forces and these institutions thought about Indigenous women and our parenting abilities. And so she has documented that most, and I quote, "most of these sterilizations took place outside the reach of the official policy, although the coercive nature of these operations is difficult to ignore." And so this has been going on for quite some time. And she also noted that Aboriginal women fared the worst and shared the gendered bias against non-Aboriginal women, as well as on the basis of race. And so there is a double oppression there on account of being female and on account of being an Indigenous woman. And so I don't want to go too far into the concept of eugenics, largely because it's incredibly depressing. Suffice it to say that in my opinion, in the opinion of others, it operated alongside our lack of personhood for a very long time, because of course, early iterations of the Indian Act defined a person as anyone other than an Indian for quite some time. And our people were only allowed to vote on an unqualified basis in 1962. So my father having been born before 1962, I'm the first generation of that line to be born with the right to vote. That's not a very long time. And so I essentially say that the lagging legal recognition of personhood with respect to Indigenous women was triply oppressive on the basis of race, gender, and perceived health status. So it really became an issue of entrenched dehumanization within that system, because not only before the 60s could we not vote, there was this idea that we were less human because the law made it so, right? We were not full citizens. And so this brings me to what I think is the most important part of this presentation, and that's in discussing what the legal elements of consent are. And I talk about this every opportunity that I have because I don't think that they are widely known, and I think it's important that they be widely known. And so here, I will talk about the elements of consent from the legal perspective, and those are discussed very completely in a book called Robertson and Picard at pages 74 to 121, as well as 141 to 150. And so essentially, there are four main pillars of consent. The first is that consent has to be voluntary. The second is that the person providing the consent has to have capacity. The third is that consent is specific to a doctor and to a procedure. And the fourth is that consent absolutely has to be informed. And so, beginning with voluntary consent, and before I do so, I should also say that the onus, which means it's the responsibility of the doctor to prove that all of the elements of consent have been met for there to be proper consent. A few caveats to consent, or a few things that should be known, is that consent can be withdrawn at any time. It can be withdrawn at any time unless it would make it dangerous for the physician or the surgeon to stop the operation. They must stop. And so, coming back to the first pillar of consent, voluntary consent. It has to be free from coercion and undue influence, as well as any misrepresentations. So consent is essentially vitiated, it's gone, it's erased if it's obtained in any way that is coercive, where there's undue influence, or where there are any misrepresentation. Now, where there's a power imbalance, such that persuasion and influence of a third party on a patient is really extensive, that the physician can't determine whether or not that patient has provided genuine consent. Think of an example where a woman would really like to not have children anymore, but her husband is there and saying, absolutely not, absolutely not. The physician should discuss the matter with the patient alone. And so this also applies to the physician themselves and to health staff themselves. Comments that we've heard in the course of our work with the survivors of forced sterilization are things like, you cannot see your baby until you agree to this. The doctor doesn't want you to leave until you've had this done. Don't you think it's time that you stop having children? Or in the immediate aftermath of a cesarean section, I can tie your tubes right now, to which the woman responded, do I have to decide now? And the doctor saying, well, your tubes are in my hands. And so these are not circumstances in which voluntary consent exists. And, you know, the issue of a power disparity between the physician and a patient is always something that's important in assessing whether something, whether a consent was coerced or whether a consent was voluntary. And that's because there's what's called a fiduciary relationship between a physician and a patient. And so the physician must always act in the best interest of the patient or of the beneficiary. That's the obligation of a fiduciary. So full disclosure. They also must be honest, of course. And because of the Charter and the Constitution, there's an absolute obligation that the bodily autonomy of the patient come first before any type of surgical convenience or any type of preconceived notions that physician has about the patient's parenting abilities or whether they should be having children. And also, I mean, in this respect, it's very important to ensure that the patient's judgment is not impaired by medication. So an epidural, anything that would be, you know, that would affect a patient's state of mind. It's also an important consideration that consent in certain circumstances, even if it's provided, can be what's called vitiated, so canceled. And so where a person has had some medication that can alter their mind, and if they're in an environment that is not free from coercion, there can be a presumption that consent was not voluntarily provided. And we say that we are very much in that type of situation here. And so leading on or moving on to the second pillar of the legal elements of consent is capacity. And so we say in this case that, you know, capacity is something that has to be assessed in time and place. A woman who is in labor or who has just delivered a baby is in a particular state of mind. It's called the peripartum period, if you want to call it that, by the scientific term. And it is a time that is often, most often, if not always, painful, stressful, beautiful, hard. It's different things for different people. But what we do know is that a woman's capacity is most definitely diminished while they are laboring and delivering a child, and right around that period of time. I mean, after all, making a person is not the easiest thing in the world. And the law, we say, does recognize that. And so to assess whether or not a patient has capacity, one has to undergo in law what's called a functional assessment. And first you have to determine whether the patient is capable of understanding the nature of the procedure And second, whether the patient actually understands the nature of the procedure. Now, the first one is more important than the second, and the second one only kind of informs the first. So the most important thing is this person capable of understanding what the physician is saying and what the procedure is about? And capacity, or rather, I would say more voluntary consent, involves the requirement for the patient to be in an appropriate atmosphere to consider information and to think about it. And we say that when a woman is laboring, or right around the time a woman is laboring, is simply not the time. And so in these cases where a patient refuses to consent to a procedure, including a tubal ligation, that certain others might view as beneficial or even necessary, is not an indication of incapacity. Rather, in the book that I mentioned earlier by Robertson and Picard, they say that patients have a fundamental right to make their own treatment decisions. As Justice Robbins noted in Millett versus Shulman, which is a very important case here as well, for this freedom to be meaningful, open quote, people must have the right to make choices that accord with their own values, regardless of how unwise or foolish those choices may appear to others. Focusing on the apparent unreasonableness of the patient's decision as evidence of incapacity, where the refusal, open quote, of consent is seen not as an assertion of will, but rather as a symptom of unsoundness of mind, end quote, undermines the patient's right to medical self-determination. And so that's a very complicated way of saying, just because the woman doesn't agree with you and doesn't want to do it, doesn't mean that she's not able to make that decision, even if you disagree with her. Bodily autonomy means that person decides. It doesn't mean that anyone else has a say in that, other than providing the information they need to make that decision. And there's a very on-point case about this issue in a case called Smith versus Tweedale. And it comes out of the British Columbia Court, and it was decided in 1995. And in that particular case, the court dismissed the appeal of a physician who'd been found negligent in sterilizing a birthing woman on the basis that the requisite standard of care in the circumstances of birth had not been satisfied. And so the courts have recognized that in the circumstances of birth, there is a requisite standard of care. And that is good. So the Court of Appeal recognized that the state of labor and delivery required more than a routine explanation of the procedure of a tubal ligation or sterilization. And that basically just providing a regular presentation on the issue that you would in any other circumstance is not appropriate when a woman is birthing. We would even go further and say it's not appropriate to raise it at all while she's birthing or in labor because of the circumstances of her capacity, the stress and pain that she's experiencing. And let's be quite frank, those of us who have given birth understand that while you're birthing is not the best time to talk about whether you ever want to do it again. It's very difficult. And so here we say, although those things are true, that diminished capacity associated with labor and childbirth is it's ephemeral, which means it only lasts for a while. It doesn't last forever. And there's nothing to prevent the suspension of the discussion about sterilization or tubal ligation until the woman is in a headspace that she can think about whether she actually wants to do that or not. Now, childbirth, we're not saying is the subject of it doesn't render a woman incapable, generally speaking. In fact, it's some of the most capable work is being done during labor and delivery and giving life. But what we say is that what doesn't need to be considered at that time shouldn't be. There are other things that are important to do then. And so Now moving on to the third pillar of consent, which is that it has to be specific to a doctor and to a procedure. The Supreme Court of Canada has decided that a doctor's liability for battery, which is far more serious than negligence, arises if, open quote, emergency situations aside, surgery or treatment has been performed or given beyond that to which there was consent. And so that statement came from Rebel and Hughes, and it was issued quite some time ago by the Supreme Court. In another case called Canis versus Sinclair, which was issued in BC in 1989, the patient requested that her sterilization be done by clipping instead of cauterization. And so that's the reason this pillar is really important, because tubal ligation can be affected in a series of different types of ways. So you have tying and cutting, you have tying, cutting, and burning, you have clips, you have all kinds of different ways. And of course, a doctor or an obstetrician or gynecologist would be in a much better position than I to explain what the different types of consequences or risks or benefits associated with each and every type of procedure may be involved. Now, in this particular case, in Canis versus Sinclair, the patient had decided that she wanted to clip her tubes or have her tubes clipped because she thought she had a better chance of a successful reversal if she decided that she wanted more children. Instead, the doctor cauterized the patient's tubes because he was experiencing challenges inserting the clips. The court found that the doctor was liable in battery because the method he used was explicitly contrary to the patient's specific request, and there was no emergency to justify deviation from the patient's wishes, which had been to use clips, not to be cut and cauterized. And so this also means that when you're having a discussion or a consultation about a possible procedure, especially one that is elective, like a tubal ligation, that is permanent, like a tubal ligation, that is non-therapeutic, that is not medically necessary, though it may be advisable, it is really quite important that the surgeon have that discussion with the patient themselves in an environment where the patient can give their consent voluntarily if they choose to do so, with no coercion, no misrepresentations, and that they have the capacity to do so. So no great stress and no tremendous pain. Now, the fourth pillar of informed consent, or the fourth pillar, of the legal elements of consent, has to do with informed consent. And informed consent is its own doctrine and law. It involves the need for the physician to do a lot of things and to provide information about all of the patient's options. Now, when we're talking about a tubal ligation or a sterilization, we have to understand that that actually has to do with birth control. And so birth control is not only achieved through a tubal ligation. There are many other ways. There are IUDs, there are birth control pills, there are a series of different kinds of ways to go about that. And the doctor has to talk about all those ways, right? And talk about what the benefits, the risks, and the consequences of employing those ways or using those methods, what they may be for the patient. It's not up to the physician to say, I prefer this, or I think you should do this. It is, here is all of the information. Now make your decision based on what your life plans are, your family plans are, what your personal preferences are. There are some cases where women opt for Depo-Provera, and I have heard, whether or not it's true, that that can have an impact on milk production. Now, that is a consequence or a side effect that a mom has to know about if breastfeeding is very important to her. And so these are the kinds of things that have to be shared. Now, when we're talking about a tubal ligation, it is extremely important that the patient understand the chances of a successful reversal or a successful pregnancy if this procedure is used. And so the courts have found that where a patient is not adequately informed about all of their options, the benefits, the risks, consequences, that we're into the territory of negligence. Now, if the patient's not informed at all, then we're talking about a battery, which is far more serious. And so the applicable standard of care, the court has found, is breached when a physician fails to explain the procedure that they were undertaking, alternative methods of tubal ligations, and because, and also could be breaching the standard of care where the physician fails to ensure the patient understands the information that is disclosed. And so here is where we also talk about the importance of a proper environment to consider the information that's been what we call imparted or shared by the physician. So in the hustle and bustle of a labor and delivery room is probably not the best place to sit and have an extensive conversation while you're in pain or recovering from birth, contracting, tired, about whether that is a process you wish to undertake again. And so the court, in the case that I was talking about a little bit earlier in Smith versus Tweedale, found that the information that the doctor shared in those circumstances after the patient had been in labor for 13 hours, that the information he had shared had been insufficiently clear. And so he was found responsible. Another case that is of interest here is Murray versus McMurtry. And that decision was rendered in 1949. So we're talking about quite some time ago. And that decision establishes that a patient undergoing surgery with respect to her reproductive organs has the right to consent to all procedures associated with that operation. In that particular case, a patient underwent an operation to have a cyst removed from one of her ovaries. The physician, while operating, discovered additional fibroids, and he took the liberty of tying both of her fallopian tubes on the basis of his justification that there was an increased risk for an ectopic pregnancy. This had not been discussed with the patient. And so the court determined that the patient, by virtue of her inalienable right to bodily autonomy, so inalienable essentially means nothing can change it, it's absolutely hers, and no one can pierce it unless she consents through all of these requirements, that she had the right not to be subjected to the secondary procedure without her consent. The court also very significantly says that convenience to the physician did not operate to cure the battery, which the court ultimately found had been inflicted upon the patient. And so because it was more convenient to do it once, because you don't want to put patients to sleep very often, and since you have them open, you may as well do what has to be done, that's not okay. The court said, no, that's not okay. The patient has the right to consent and have information about each and every single procedure one is proposing to effect on that person. And so what do we see here? What we see here is a practice. It is a treatment that Indigenous women are being disproportionately subjected to, that is blatantly contrary to law. And so what do we do about that? How do we deal with that? Well, of course, we do all the work that we can to inform one another about what our rights are. And I think that that's where prevention starts. But all the work is not necessarily on our shoulders, and I don't think that it ought to be. With respect to the cautions, I think that any woman considering birth control has the right to know that it is her decision to make and what her rights are with respect to the type of information that she has the right to receive under law. So we say that what's called a constitutional caution in these circumstances, and at least some uniformity or some consistency across the country with respect to what kind of information is shared about birth control with women, should be undertaken, and that work has to be done quickly. Of course, we brought this case to the United Nations Committee Against Torture in Geneva. At the time, I was 32 weeks pregnant, and it was a very long trip, being that big. But it was very worth it, and we think that we did some good work there. And ultimately, the UN committee told Canada, hey, you have some work to do. You have to prevent this. You have to punish the people that are doing it, and you have to provide reparations to the survivors of this practice. Because you know what? Forced sterilization is torture under the UN Convention. It's not only, though it is, cruel, degrading, and inhumane treatment, but it is considered torture. And so what has Canada done? We say very little. What has Saskatchewan done to make sure that this doesn't happen anymore? What have they done to punish the people who are responsible for it? And what have they done to try to repair some of the harm to the extent that is possible with the survivors? Nothing, absolutely nothing. In fact, when we returned from Geneva, just a few weeks later, we received a telephone call from a woman in her 20s, a young Nakota woman who'd just given birth and who'd just been forcibly sterilized. A few weeks after we came back. And so we see that, of course, systemic issues require systemic solutions. And far too often in the kind of work that we do, we take that on ourselves, and we push hard and we say, what can we do to change this or to change that so that they change? And I think that it's important, especially in circumstances like this, to lay the blame at the feet and on the shoulders of the persons and the institutions who should bear the weight. Now, these institutions, the health system, the public health system, has obligations to the public, and Indigenous women are part of that public. Whether or not we achieve personhood on a delayed basis is another question. Whether or not they choose to view us and treat us as human beings is another issue. But do we have the leverage in the law available to us to make it so? We most certainly do. And so one of the most effective preventative means, strategically speaking, I believe, and some share this view, is not really to change hearts and minds. Education can do that over the medium term, over the long term. But as far as protecting ourselves, our bodies, and the bodies of our children, and of our nieces and our aunties and our sisters right now, we absolutely must call these things for what they are and demand some accountability and put it in the wheelhouse of the institutions that are causing the harm to renovate and to reform themselves. This is not a question of having more midwives in reserve-based communities, though that would be great, that would be wonderful. The issue is about the right of our women to present at publicly funded hospitals and to have babies without being treated terribly and walking out with their fertility if that is their choice. It is a very simple right, and it is a right and a way of being that most people take for granted. But as we know, our hills are quite a bit steeper to climb, and our challenges far more difficult than they should be to beat down. And so with respect to what's happening in our advancement of this case, we represent over 100 women. Close to about 65 in Saskatchewan have disclosed that this has happened to them. I expect there are far, far more. And I understand why they're not coming forward. Why would they? You know, why would they relive something so terrible unless there's some kind of reason? And I can say with all the confidence in the world that there's no amount of money that will provide what was taken or that will replace what was taken. And so it is very understandable why some people would not want to come forward. That being said, the work that we are doing on a class action basis will be for those women if they decide they do want to come forward. And when they come forward, if they come forward, it won't have to be public. That's why we're doing this with what's called a narrow publication order. And so the identity of the women is not known other than through their initials. And there's good reason for that. There's good reason for that because when the women initially came forward, especially in Saskatchewan and Manitoba, they were berated online and they were treated absolutely terribly. The very fiber of their being was questioned by people who didn't even know them, essentially telling them that they deserved whatever happened to them. And so when those kinds of things happen, as disappointing and heartbreaking as they are, it reminds us of why we're doing this, because there's a lot of change that has to happen. After all, if a pregnant woman isn't safe giving birth, and if her wishes are not respected giving birth, then where can we be safe, is of course the question that immediately comes to mind. At a personal level, I have to say I'm a Mi'kmaq woman from the East Coast, but I am married to a Cree man from here with connections to both Moosomin and Pachanak First Nation. And, you know, when I was pregnant with our babies, his mother was very adamant with him. Get her whatever she wants. Never raise your voice. All of that goes into the baby. Be very careful. And so when this case came about and I thought about the cultural clash that's involved, you know, I remember being in that state and just trusting whoever was around me because I had no choice, because the vulnerability was just so great. And so I think about the opportunism involved in seeking consent from a woman in that particular state to have her forever abandon her ability to bear children against her will. Because of course some women want that, and that's also a function of their will. And I think that we have a lot of work to do to bring about the change that is absolutely needed. And I can say that our clients are, you know, the absolute champions of these issues. They have gone through it. They have gone through it. They have gone through all of it. And, you know, when you ask them what's the most important thing to you, what do you want to come from this? The singular answer is, I don't want this to happen to my daughter or my daughters or my nieces. I don't want this to happen anymore. And so their motivations and their intentions are extremely altruistic, as they would be. And I share that with them. I cringe at the thought of my children giving birth here, and hope that when their time comes, it'll be safe to do so. So with that, I thank you for your attention and for your invitation, and I ask you all to be kind with yourselves. This is a lot of difficult information to take in. It is intended to empower, but I know that it can inflict a lot of pain. And so don't hesitate to reach out to your supports, whomever, whatever they may be, to talk anything out that has to be talked out, to take good care of yourself, and to reach out to people when and if you need any kind of help. That being said, we're always happy to answer any questions about you know, the law in this area, and about what is happening and about our efforts. We try to keep the FSIN updated. Sometimes things move a little faster than we're capable of briefing on, but we are here. We're in Saskatoon, and if anyone has any questions, they should feel free to call our office or to come by with an appointment so we can have a discussion about it. Thank you very much. Hi.